All right, happy Friday, everyone. My name is Alexis Alvarez. I am the Director of Statewide Training at Florida Legal Services. And we are here today as I believe the third part of our Domestic Violence Awareness Month training series. And today we will learn about when Chapter 39 crashes into Chapter 61 and Chapter 63, avoiding the collision and minimizing the damage to domestic violence survivors. And before I go into introductions, I'm going to share our slideshow and I'll keep talking from there. Give me 1 second. Here we go. Perfect. All right, thank you all for your patience. So always starting off with our housekeeping announcements. This is being recorded and a copy of this recording will be sent to all registrants. And folks, if we run past 1 o'clock, please feel free to drop off and go back and do what you need to do. The recording will continue and we'll make sure that you get all that content later on in the follow-up email. So thank you for being here and thank you for staying as long as you can. Second, CLE credit. The Florida Bar is still processing this course for CLE credit, but don't worry, they confirm that it is in process. So you will receive an email with the recording materials, but it will not provide the CLE code, and I will not be able to provide the CLE code today. However, I will follow up with you as soon as I get that code. I have all of your emails, everyone who registered, and I will personally make sure that you get that CLE code and that CLE credit. In the email, you'll have my email address, and you can always feel free to reach out to me and say, hey, Alexis, any update, any status on the CLE? Always happy to provide clarity and give you all the information that you need. And so last bit of housekeeping announcements is I should have enabled the live transcriptioning. You should be able to see everything that I'm saying coming up in a black box at the bottom. I'm screen sharing today, so I'm not going to be able to check the chat box, or I'm not going to be able to answer any of your questions as they come. But our presenter, Janine Rice, is going to be monitoring the chat and is going to be able to let me know if anyone's having any issues. And finally, before I go into any introductions, I do want to say this is being co-sponsored by the Public Interest Law section of the Florida Bar, specifically the Parents Advocacy Chapter. For those of you who might not know, but the Public Interest Law section of the Florida Bar is an amazing, amazing chapter focused on public service and public interest law. And the Parents Advocacy Work Group, subject matter work group, is a work group specifically dedicated to exactly that subject. So if you're in this field and you're looking for a network of people to bounce ideas off, to have resources from, please join. I'll send that information out as well in the follow-up email. And as soon as I'm done screen sharing, I'll try to pop some information into the chat. But I highly recommend being a member of PILS, the Public Interest Law section of the Florida Bar. It's a really great organization with really great people. So without further ado, I'm going to go into our introductions of our presenter here today, Janine Rice. Janine spent 3 years in the Domestic Violence Unit of the Office of the State Attorney for the 17th Judicial Circuit, using 911 calls and independent witnesses when victims would not cooperate. She then worked at Children's Legal Services, prosecuting civil cases in the child welfare system, followed by a year at Broward Legal Aid Services, representing children in the dependency system in their efforts to receive free, appropriate public education. She then spent 2 years at the Office of Regional Counsel, representing parents in dependency and termination of parental rights proceedings. She presently serves as a pro bono attorney ad litem, a court-appointed attorney ad litem, and as a parent's attorney both privately and court-appointed. Many of her private family law cases involve post-judgment actions regarding timesharing, substance abuse, mental health, and domestic violence. We're very honored to have you here today, Janine. Thank you for being a part of this important month of awareness and our first ever domestic violence training series. With that, the floor is yours and I will stop talking.
Okay, thank you so much. It really is a pleasure for me to be here and to share my experiences. I'm certainly not going to hold myself out as an expert on the law. But I have spent a lot of time in this area, not only here in Florida, but I have some past experience in Maryland as well. And it's my passion. It's something that I feel like I've been called to do. So feel free to correct me if you have better knowledge than me. But I'd like to just give some context to my experience dealing with Chapter 39 and domestic violence, and as that overflows into family law. So to start out with, I'd like to talk about why collateral consequences of domestic violence matter. And what do I mean by that? Just generally speaking, it's hard, I think, as an attorney, when you're representing a client, whether it's somebody who is considered an offender or whether somebody is considered non-offending. The different layers and the different consequences from all the different moving parts of our legal system can really have unexpected consequences. From the criminal courtroom to the injunction courtroom, the family law courtroom, and the dependency courtroom. And I used to say that dependency was where family law and criminal law intersected, but it's so much more. Because of substance abuse and mental health issues, you have to have some familiarity and knowledge of Marchman Acts and Baker Acts as well. So, you know, if you take a holistic approach to the practice of law, this is a great area for you. That being said, I want to talk first of all about who is a mandatory reporter and how that affects our clients. Everyone here is a mandatory reporter. You know, people used to say, and to this day, you still hear so-and-so is a mandatory reporter, or like the teacher or the doctor. But if you look at the statute with regards to required reports of child abuse, it's Florida Statute 39.201. And the very first section says a person. So as long as you're a person, you are required to report immediately to the Central Abuse Hotline. And there's now very techy kinds of ways of doing that, not just fax machines and telephone calls. If you know or have reasonable cause to suspect that abuse, abandonment, neglect, etc., is laid out in the statute has occurred. So who are all these people? Well, the first time you walk into the clerk's office and you file that, the petitioner files their pro se petition for domestic violence, the clerk, especially I know in my county, but are trained to do this, but the clerk is required to fax that and send it up to the Central Abuse Hotline, because it's sworn under oath and there's reasonable cause just based on the affidavit. And it's actually clerks who are doing this. They're not directed to do it on a case-by-case basis. So I say that because the odds of a case ending up on the radar of DCF can happen as an unintended consequence. And I'm not saying don't file the petitions, just know that that's a likely outcome. And what will happen after that is the rest of this talk. When you, as an attorney, are seeking emergency relief in family law, usually the administrative orders for such relief indicate that it has to be in situations that encompass the likelihood or actual abuse, abandonment, or neglect. So, you know, if DCF is not involved already, they should at least be getting an intake on that, and they can screen it out, you know, when they receive it, or they can refer it out for further investigation. But there are a variety of sources and ways which the allegations get reported to the Central Intake Hotline. Another one is law enforcement. So when a police officer is dispatched in response to a 911 call, and there is a child who is present, whether they were actually exposed and in the same room or not, and we'll get to the definitions of abuse and neglect later on, but law enforcement is a person with that knowledge, and they can be and should be, according to the statute, required to report immediately. In the state attorney's office, in the case filing unit, particularly in the domestic violence unit, there is nothing that requires the case filer to check and see who else may have already made the report. So when they see that probable cause affidavit, they are going to fax, scan, or do whatever with it up to the, and I say up because visually in my mind it's in Tallahassee, the child abuse hotline. Those are just the kind of legal channels. Then, of course, you have what people historically have thought of, which would be healthcare providers, whether it's a mental health counselor, a doctor, a nurse practitioner, educators, whether it's support staff, a teacher, an administrator, daycare providers, anybody who comes into contact with a child and they know or have reasonable cause to suspect are required to report. And there's no distinction between civilians and professionals. There's neighbors. So the neighbors keep hearing, you know, the fights and they're worried about the children. A neighbor could call 911, but a neighbor could also report it to the child abuse hotline. And then, of course, those are people with the best of intentions. We also know that there are people who don't always have the best intentions. And so we also are aware of, and we're not naive, that people can make reports that are not made in good faith, or they're made with ulterior motives. And so there's not always, just because a report is made doesn't mean that it's made in good faith. And then, of course, there's statutes that deal with that, knowingly making a false report. So at the hotline, you know, they make a decision there based on their training and experience, whether to screen a case in for further investigation and refer it out to the field, to the troops on the ground in the community, or whether to just handle it internally and close it. But once that case gets referred out, then you have the investigation by the child protective investigator. And that's where I want to turn next to the prevention and the what the community can do to prevent a removal. But before I do that, I want to answer a question. Thank you for the question. What about attorneys as mandatory reporters? There's a few years ago in which a Florida legal aid lawyer was disciplined for reporting child abuse allegedly committed by her client. I should have anticipated this question. The obligation or moral duty to report abuse versus the duty of confidentiality. So maybe we should definitely add that on. And if you would like, because I'm not prepared to answer that, I just wanted to like issue spot and let folks know where all the different sources are. But yes, as an attorney, you are a mandatory reporter, and you know, each case depends on its own facts. But I'll give you and I hate war stories as war stories, but I think it helps flesh it out and give context. There was a time when I was prosecuting children in dependency for their alleged delinquent acts. And my counterpart was an amazing assistant public defender. And she was aware of certain things that were happening in group homes. Sometimes her clients did not want her to report them, and sometimes they did. And I know that she personally, I never knew what the outcomes were because that was confidential information. And she never shared with me the details, but I do know that there were occasions when she did report it, and there were occasions when she didn't. And I will tell you that it's beyond my expertise to respond to that question, but I would like to be able to answer it. There is in the statute certain people who must not remain anonymous. And that probably is where folks get the concept of a certain profession is a mandatory reporter. And they're outlined: physicians, healthcare professionals, mental health professionals, practitioners who rely solely on spiritual means for healing, school teachers, school official personnel, social worker, daycare center worker, foster care worker, a law enforcement officer, judge, and an animal control officer. Now, these people must provide their name to the Central Abuse Hotline counselors. And why is that? Well, because it makes for a better investigation. So unless you fall in one of the enumerated, whoops, that's blurry, but in one of the enumerated categories and 39.2011(1)(b)(2), you can report anonymously. And an attorney is not listed as someone who must disclose his or her name to the Central Abuse Hotline. I don't know if that helps answer the question, but it's definitely a place to start with regards to the research on the issue. I, of course, suggest that there's attorneys who practice in representing attorneys, and I'm sure an ounce of prevention is worth a pound of cure. So if you ever have the question, you should always be very diligent and do due diligence and make sure that whatever action you choose is based on at least having the knowledge of acting in the right way. Whether ultimately legally it's not the right way, at least you did your due diligence and you're not just shooting from the hip, as they say. There's nothing in the chat. So alternative remedies to removal. A variety of options are available. There's legal ones and there's non-legal ones, or judicial and non-judicial. So the ones that I think folks can take advantage of is what we would refer to as our kinship care unit at Legal Aid in Broward County, but essentially it's temporary custody or concurrent custody. And that is, and I've worked with some child protective investigators here in Broward County. Once they became aware that I was willing to do these things like on a low bono basis, I've had people reach out to me now and say, you know, I would like to keep my child from being sheltered in the first place. Can I place my child with my mother? Can I place my child with someone who is like family? And the child has to physically be that with that person, and the language recently was broadened to include people who are like family. But the one sticking point of this alternative remedy is that the child has to be in that particular home at the time the petition is brought. And I even came across a case where it appeared that the parent was petitioning, which to me makes sense, right? This is something that you want for your child. But I think there was some discussion about, you know, you have to take the language in the statute literally. And so I think if a parent wants to be the moving party, they could do it jointly. You know, for example, the relative might not have the funds to do this, might not have a unit or availability at legal aid to be represented, whether they make just too much money or whatever the grant funding restrictions are. And so the parent who may have the substance abuse issues may also be very gainfully employed and want to hire an attorney to protect their interest and move this forward. So, you know, you just have to think outside the box, but stay in the lane that's set forth by the legislature. So that's one. That's the temporary or concurrent custody. So temporary custody, for those who don't know, really is for when the moving party and the parent don't agree. And if one parent doesn't agree or one parent cannot be found, then it would proceed as temp custody as to that parent. The consenting or agreeing parent, and they've worked out basically the case plan, if you will, for lack of a better word, that would be concurrent custody with that person. And there, we could do a whole lecture on just on temp and concurrent custody, but just know that those are out there. Read the statutes. It's a way to keep a lot of these cases that otherwise would qualify for removal and the trauma of removal from getting that far. Non-judicial case plans or interventions. So you have the CPI out there. You don't have a judicial remedy that can be handled privately amongst the family or the folks who are like family. And perhaps because the parent's mental illness has alienated all friends and family and they're really isolated and alone, or they've just burned all their bridges from their addiction and the behaviors they engage in order to feed financially their addiction, and they have no remaining friends or family available. So what can be done? Well, we have resources in the community because it's an ounce of prevention is worth a pound of cure, and it's folks have found it's more cost effective and less emotionally tolling on the children to not go through the unknown. And so the parent consents and says, I'll go for inpatient treatment. I'll accept your services. And there's a safety plan and a safety monitor. And I don't know exactly where everybody works or what area of law they practice in. So if I am preaching to the choir, I apologize. I'm sure there's plenty of you out there who know more than I do about this, but I really wanted to provide this as an overview or some insight, and also get on my soapbox a little bit about these alternative remedies to removal, because the trauma that the children go through, I don't want to say forget about the parents. Trust me, I know the parents are traumatized by the removal, but the children themselves can get traumatized, not only by whatever chaos is going in the home, but by a sudden knee-jerk reaction, perhaps well-intended, and ending up with complete and total strangers who know nothing about their likes and dislikes and idiosyncrasies and disabilities. So to that end, when we can do things community-based without judicial intervention and have ownership of the problem and have ownership of the solution, that's ideal. My soapbox moment is going to say that if we, and there are studies out there, there's a lot of data. There's a lot of studies about how it is much more cost effective to prevent a removal and keep children in the home or in the family. And I love the way that the family has been defined more recently in the definitions. Family means more than just the person who contributed to your existence with their sperm and their egg, right? Family is a lot more than that. And the legislature has begun to recognize how important family as a larger concept is to children. Okay, so safety plans and safety managers. The challenge, as I kind of distracted myself there, I apologize, but the challenge with safety plans and safety managers is that you have to have somebody that is trustworthy, will pass the background, will have the backbone to enforce the safety plan, but the empathy and compassion to understand the dynamics of what the parent is going through and what the children are going through, and to not use it as another tool for power and control. A lot of our clients are in relationships with parents or new partners or different partners, and we have these issues of power and control, or else we wouldn't be sitting here talking about domestic violence and its intersectionality. But sometimes the apple doesn't fall far from the tree, and the folks in the family also have a bent towards using power and control. So we don't always have the best person to be a safety plan manager. And this is going to be me spreading the word, if you will, and seeking out folks in this area, wherever you are throughout the state of Florida. If you could, if you're a very community-based person and you work with a variety of community-based agencies, there are plenty of people out there who are looking for things to do to make children's lives better. And I don't mean it from the negative connotation of a do-gooder, but I mean really people who have time and desire to serve like a family member and serve as a safety plan manager, maybe to supervise visits or things like that. We do not have enough government resources for the department and its vendors. We don't have enough direct biological family members who are willing and able to serve in this capacity. So we really need to look out into the community to a variety of, and come up with creative solutions on how we can preserve these families and keep them together, or at least as normalized as possible, without intervention that arises to the level of a removal. Okay. So moving on to the next topic that I wanted to talk about. Why doesn't the victim leave, right? I don't know if any of you have, so my first exposure to domestic violence was as a prosecutor. And traditionally, my more traditional conservative colleagues as prosecutors, I mean, they would verbalize this out loud. and not, yes, in the 1990s, but also as recently as, when was it, like within the last 5 years, if not, which I guess was the last time I dealt with a prosecutor in domestic violence. But this whole, why doesn't the victim leave? And like, prosecutors literally say things to victims that makes you scratch your head, because when a victim is ready, having been told, well, don't come back here again, we won't help you the next time if you're not going to accept our help now, right? So I think that a lot of prosecutors have moved beyond that, but every now and then there might still be a trace of it. How does that apply, and why am I talking about it in the context of family law and dependency? Well, because as recent as this yesterday afternoon, I had an attorney representing the department talk to me about, well, they're still in a relationship together. They're still together. And my client, who's the father, was stabbed in the back. And it was a pretty bloody, gruesome crime scene. And people just sometimes cannot wrap their minds around the fact that for a variety of reasons, families want to stay together. And they're, depending on the facts and the circumstances, and each one of these cases is very fact specific, but we should realize that there are financial reasons. And again, this goes to insufficient resources causing cases to come into care. I've had folks tell me a variety of reasons, and they're all legitimate. Let me tell you, childcare, pure financial reasons, housing. We live in a society where it's very difficult to be a single parent with a full-time job, childcare. I'm sure everybody here knows these things, and I'm probably belaboring it, but there's case law, there's cases out there that speak of this, and you're sitting here going, they give lip service to it. There's actually a case in the materials that sort of gives lip service to, yes, we understand why victims of domestic violence may remain with their abuser, but and so thank you for that acknowledgement, and then goes on to explain why in this particular case the child has to be removed and alternative remedies don't work. What just as in the prosecution of these cases in a criminal courtroom, I think we would have much different outcomes if on the front end we loaded resources for childcare, transportation, and if people would actually ask the victims, what do you need and how can we find that? Can we as lawyers solve these problems? No, not necessarily. If social workers were available and had specific knowledge of the variety and perhaps not well-known resources out there, we would do better. I speak as someone who used to work in the Office of Regional Counsel here in the 4th DCA. And we have an amazing forensic social work program, or they, I'm not there anymore, they have an amazing forensic social work program. I will tell you that the special public defenders do not have that. And my clients need someone when I'm not available. They need someone who knows the community intimately to help them with the housing and some of these other issues that are preventing them from either getting reunified or facing a second removal. Okay, so statutory definitions of abuse, neglect, and the risk of imminent harm. So here's the law stuff. 39.01 Florida statute, 15 pages of definitions. We're now up to, and the last definition, by the way, interestingly enough, is a victim, the definition of a victim. It's the 87th definition in 39.01. But the ones that I want to focus on are abuse, neglect, and the risk of imminent harm. And it's actually, we have a shorthand way of saying that in my community. It is, it's a shorthand that we use, but let me explain it better in a moment. So abuse is essentially harm that causes or is likely to cause, and I want to focus on the challenging parts of the definition. Likely to cause the child's physical, mental, or emotional health to be significantly impaired. So these are tenuous things, right? Harm that is likely to cause the child's physical, mental, or emotional health to be significantly impaired. Harm can occur when a person inflicts or allows to be inflicted upon the child physical, mental, or emotional injury. Neglecting the child and there's, I'm going to go through some cases that really address neglect. When and this falls under harm, sorry, engages in violent behavior that demonstrates a wanton disregard for the presence of a child and could reasonably result in serious injury to the child. Negligently fails to protect a child in his or her care from inflicted physical, mental, or sexual injury caused by the acts of another. That's the whole failure to protect. Some other terms that are important are impending danger. Listen to how broad this is. So a situation in which family behaviors, attitudes, motives, emotions, or situations pose a threat that may not be currently active, but can be anticipated to become active and to have severe effects on a child at any time. Mental injury means an injury to the intellectual or psychological capacity of a child, as evidenced by a discernible and substantial impairment in the ability to function within the normal range of performance and behavior. So, you know, if there's no actual harm, there's, which, you know, you're looking at it and you're like, oh, well, it seems to me that that's going to be something that might be very difficult to prove, that sort of injury in domestic violence, unless, of course, you have a child who's experiencing symptoms of post-traumatic stress disorder, or often a diagnosis which applies, but is given the label of ADHD, but the co-occurrence with PTSD, or, I mean, we can do a whole nother presentation on that, but neglect occurs when a child is permitted to live, and this is the one that the cases focus on for domestic violence, okay? So neglect, and this is the easiest part to prove. Neglect is when a child is permitted to live in an environment when such environment causes the child's physical, mental, or emotional health to be significantly impaired or to be in danger of being significantly impaired. Present danger, which is different than impending danger, obviously, is when a significant and clearly observable family condition is occurring at the current moment and is already endangering or threatening to endanger the child. They are conspicuous and require immediate protective action to be taken to ensure the child's safety. So what this boils down to basically is when the victim remains in the home, in the relationship with the offender, with the children, he or she, the victim, is treated as failing to protect the children from exposure to the chaos, the tumult from the domestic violence. So let me turn to the cases. There's 3 cases that I think are really strong jumping off points to understand what the domestic violence victim is looking at with regards to a Chapter 39 proceeding. And I'm just gonna share with you blurbs from specific cases that to me seemed very typical, what I frequently ran into both as a prosecutor and also as a parent's attorney. So in this one case, it's out of my circuit actually, and with one of my favorite judges, a mom gets taken to hospital by ambulance, complaining of pregnancy-related bleeding, and she's concerned about her young child, who's about 1.5 years old, staying with the offender's family. And as she shares with the medical staff her concerns, they tell her, well, we're going to call the police. So she begins to recant. And then, of course, bing, 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 failure to protect alarm bells go off. Law enforcement comes, and on the one hand, she starts off by being very candid, scared for her life, concerned for her child's safety with the offender. There's bruises observed. And then again, when she learns they're going to arrest him, she recants. She tells the CPI, the child protective investigator, he was only hitting her and not the child. That he needed to be in the home to take care of the child. She did not have any relatives in Florida. It turns out this was not quite accurate, and I don't know why she didn't want her parents involved, but that her family lived in Haiti. She may have had good reasons for them to not be involved, but when had she been more forthcoming, had those, and ultimately they were the placement after the shelter. Sometimes, they handle those things informally, and it wouldn't have reached to this level. So they file a dependency petition against her, saying that she neglected the elder child and placed both children at substantial risk of harm. And she says, oh, I made this all up because I was jealous. I was just upset. And, you know, this was all done just to retaliate against him. The court goes on to say, in expounding upon the statutory definitions and fleshing them out, that it is not necessary to establish that a child saw or even was aware of the domestic violence for a finding of neglect. We sometimes see private criminal defense attorneys over in our Chapter 39 proceedings, and they take a criminal defense approach to these dependency trials and kind of miss this case law. So this is why I wanted to point it out, that it's not necessary to establish that the child saw or was aware of the domestic violence for a finding of neglect. It's abuse if the child is present, but neglect doesn't even require the child to be aware. When there is a history of domestic violence and the parent's relationship is ongoing, so those are the two conditions, a history, so more than one domestic violence incident and the parent's relationship ongoing, prior incidents of domestic violence can support a finding that a present threat of harm exists. In a different case, the situation that gave rise to the isolated domestic violence no longer existed, and the children were not exposed to a present threat of harm by continued acts of domestic violence. So in your materials, I want to direct your attention to JD versus DCF, which is from the 4th DCA in 2019. CJ versus DCF, another 4th case from 2007. And let me just grab a couple of thoughts out of that one. And that one, the children were not in the same room, but they overheard it. So in the presence of does not mean like in their visual eyesight, it can also be within earshot. And it is not always necessary a child be physically present in the room in which an incident occurs to demonstrate neglect or risk of neglect. The court has to look at the totality of the circumstances and can find, just like when someone is dealing drugs out of the home while the children, where children live, it can be notwithstanding that the children were not present or even aware of the illegal activities. Why? Because of the inherently dangerous nature of what happens, drive-by shootings and the like, that put that child at risk. And so you can draw that, they draw the analogy and the parallel to domestic violence. So that's CJ, and also EH. So in EH, there's some language about mutual combatants. And I want to bring this to folks' attention. And it says, because I actually had what could have been a mutual combatant case the other day. This case where there's mutual combatants or where they can't discern who is the aggressor in every single situation. So sometimes one partner is the aggressor, in other situations, the other partner is aggressive, or you can have what we say in the criminal field, mutual combatants. This case presents a greater risk because here the department's evidence indicated that both the mother and the father, and not just the father, have engaged in domestic violence. So just some things to be aware of. Now, before we end, I do want to bring to your attention some glimmer of hope. And these are cases that and not only do they not blame the victim, but they show the path forward, why the department essentially got it wrong in this particular case. And LCA versus DCF out of the 3rd DCA, March 17th, 2021. I highly respect and like the trial judge in that opinion, but when you read the appellate's view on it, you can understand why they reached the outcome they did when they reversed. Another one is TB versus DCF, July of 2020, out of the 4th DCA. And also SH versus DCF, October 6th of 2022, out of the 3rd. Give me one moment, if you will. Sorry.
That's okay. And while you take that moment, I'll let folks know that in the follow-up materials that you're going to receive, it's going to be an email from Zoom. There will be a link to a folder that Janine shared that has all of these cases that she's referencing. So don't worry if you're not catching the sites or getting it down properly. You're going to have all of those resources at your fingertips and can always reach out to me if something with the link doesn't work or something like that.
Yeah, I think that covers it for those. Let me go back to sufficiency of the evidence. So I obviously you just basically look at your facts and say, well, do they meet that criteria? And if they're alleging abuse, then the children have to have been actually exposed to the violence and witnessed it. This one case, MV, M as in Mary, B as in boy, versus DCF. It's a second DCA case from 2006. And in it, it was a significant incident of domestic violence, but it alleged abuse as opposed to neglect. And the conclusion was there was no evidence that the children suffered any physical or mental injury as a result of witnessing the altercation, or that the father posed any current threat of harm to them. The evidence was insufficient to show that the children needed protection from their father. And also, I want to direct your attention to JW versus DCF, a 2022 opinion out of the 5th DCA. And in that one, well, there was one scenario that directly affected one child. As to the siblings, there was no competent evidence that the siblings were aware of the domestic violence, nor was there sufficient evidence to support a finding of prospective abuse. And the court was distinguishing and not lumping all the children together in reaching that conclusion. The last thing I want to touch on is, and I think I messed up my time frame, so I do apologize for that. But this has to do with two things. When is an emergency? And then once 911 is called, what do we do with that? So this is for the family law cases, right? So when you are alleging, you want to get your case to the judge faster, right? Because, for example, it can take 2 to 4 months, if not longer, to get a hearing. So you're trying to find a way, maybe creatively, to get an earlier court date. And so you make an allegation that arises under the level of the administrative order. And well, what have you now done? I'm going to loop all the way back to the beginning. You've now put yourself on the DCF radar, and you're going to have an agency intervening in your client's life, possibly, in ways that you can no longer control. So if you're a control freak like me, you really want to think strategically about when you pull the emergency card and who you are inviting into your client's family. And before I get to my last topic about 911 calls, I do want to make reference to those of you who think, like I did, that, well, of course, everybody deserves a plan to step up and out of their chaos. So think of your folks who have mental health issues, or your folks who struggle with substance abuse and are domestic violence victims, because oftentimes there's some, those things definitely go hand in hand, given the trauma from their past relationships, or the fact that the offender thinks that they can prey upon them because of these perceived weaknesses. In any event, you have a family law case, it's not a Chapter 39 case, and you know, it was kept off the radar. DCF did not get involved, and the weaker parent decides to agree to a certain time sharing schedule, knowing that they're on the path forward. They are going to find their way up and out of their chaos. They're just not there yet at the time of the final hearing. And so to change that in the future, they're going to need to prove a material, unanticipated substantial change in circumstances. Like getting sober, like getting a job, like having all the things we expect in a Chapter 39 case plan, right? Stable housing, stable income, clean and sober, consistent period of sobriety. Well, the case law suggests that that should have been anticipated. You should have anticipated that you were going to do all those things at the time of the final hearing. And people who have made remarkable strides in their life have become the healthier, stronger, better parent, don't get the benefit of a reunification case plan in Chapter 61. And man, I sat there when I read those cases for the first time, and I was like, okay, so here's when it's a good thing to be in dependency court. So I just wanted those of you who practice in Chapter 61 courts to be aware of that. And then my very last piece before we go is 911 calls. Get them and listen to them. What do I mean by that? Okay. Whoever is responsible for recording and dispatching from 911 calls maintains those records for at least 30 days. They are effervescent. They do not sit around and wait until you're the day before trial. You need to get them immediately. You can order them. I don't know if it's every agency has this. Some can be ordered online. Others, you know, I like the old-fashioned way of picking up the phone and calling to records and calling around and finding out who should I call and speak to in order to order them. But get the 911 calls, no matter what. And if you're representing somebody, you need to make some strategic decisions, okay? Are you going to put your client on to testify? Are you going to go to trial and have the judge hear the 12-year-old describing to the 911 operator hysterically in a panic attack, full-blown, what she felt like when her mom pointed a weapon in her face to discipline her and how it affected her little siblings? Like, do you want that information to come out in court? And if not, how do you, strategize? Is it admissible? So if she's not hysterical, if it's not an excited utterance, if it's not admissible under the progeny of under Crawford versus Washington, it's either going to be a play-by-play, which is a present sense impression, or it's going to be an excited utterance. Those are pretty much the two exceptions to hearsay that allow 911 calls to be admitted. And so get them and listen to them, because one, they can help you tremendously if you're representing a non-offending parent. And if you're representing the offending parent, you want to do damage control. So there's a whole body of case law in the criminal field, but it can be used in civil as well. It just, take out the part of the right of confrontation that only exists in criminal, but the hearsay issues still apply. And that is, can I get this call in? What will it prove? And how compelling is it? I mean, I have listened to some very cold and clinical descriptions of what took place. And in those cold and clinical descriptions, because they weren't close enough in time, or because it wasn't a truly excited utterance, but they're telling the truth, you don't get the 911 calling. Of course, if you have the cooperating witness, you don't need them. But I feel like not enough people pay attention to this amazing piece of evidence. It can hurt you and it can help you. But you don't know that if you don't have them and you don't conduct the analysis. So that being said, we are technically over, but I don't see any more questions and answers in the chat or in there. So do you want to throw it open, Alexis?
Yeah, awesome. No, thank you so much for that. And folks, if you do have any, last minute questions, please feel free to drop them in the Q&A or the chat while we wrap up with our housekeeping and stuff like that. We can definitely answer them. I was thinking when it comes to 911 calls, I'm a former public defender, and so many times by the time that I got the case, and I'm speaking from public defender world, it's different maybe in dependency. I'm not as familiar with, in family court, I'm not as familiar with the process. By the time that I'd get the case and actually be able to look at it, most of the time the 911 call wouldn't be available anymore, which was such a shame. I wanted it, right?
Exactly.
Yeah, and usually the state attorney had it eventually and gave it to me eventually because they got it right away, and turned it over. But for folks that don't want to rely on waiting for the other party to turn it over, the other side, what's the best way to approach, getting that 911 call? And I know you said online, or I know you said calling, but, is there a motion to preserve that maybe should be filed?
Oh, yes, absolutely. So that's what I'm talking about, the effervescent evidence. Like literally, they have a 30-day destruction policy.
Right.
And so if you don't get your request in within that window, it might not be there.
Yeah.
And, not everybody knows to preserve it. Right. From a law enforcement perspective, like they may not be thinking, because they have this really great case they have super cooperative victim that they have on tape. They've got these gruesome photos, but if that victim dips on you, then you really don't have anything, because how are you going to get all that stuff in? How are you going to tie it up in a nice package? So the 911 call for me as a prosecutor, and then think, okay, well, in the civil world, the plaintiff is the prosecutor, right? So how are you going to prosecute your case as a civil plaintiff if you don't have that really critical piece of evidence? What if it was the child? Like, okay, so not everybody, a lot of folks, for some reason, because children actually make some of the best witnesses. And if they've gotten the right amount of therapy from the right person in the right way, they can survive the challenge of testifying. But I mean, you can't prove, well, in other states, it's much harder to prove cases without actual witnesses. So you have to find creative ways to get that witness's testimony in. And the neighbor who calls and gives a blow by blow, the victim inside the house, who's the law enforcement officers are looking at her through the window as she's describing what's happening to her. If you don't listen to them, you don't know how good it is, depending on, again, your role, or how damaging it can be. And you may be given one version of events, and there's another recorded version that is admissible that does not line up with your whole theory of your case. And you don't want the other side to have that and then drop it on you after you've already committed.
Right.
So I guess that's the biggest thing. And so, yes, you send in a letter to the agency that does your 911 calls in your jurisdiction, in your municipality. You ask them to preserve it, and then you go ahead and request it. But if you miss that window of opportunity, they can destroy them. Do they always? No. So don't give up. But don't leave any stone unturned either.
Yeah. Just always remember, I know it's an overwhelming system, but always good to interview your clients as soon as possible, get the information as soon as possible, and then, be able to move on it. But we're all human beings trying to navigate this really tough profession. So, things happen. So with that being said, I don't see any questions that came in through the chat or the Q&A. I will, before we head out, remind folks that you will receive a copy of the recording, all of the materials that Janine referenced through her lecture. And the CLE code will not be in that email, but it will be. I will follow up with it, I promise. And you can always reach out to me directly. My email will be listed within that email from Zoom. And with that being said, one more plug for the public interest law section of the Florida Bar. Parents Advocacy Work Group, if Parents Advocacy Work Group is not what you're interested in, there's disability, there's civil rights, there's homelessness. I mean, it's a really cool chapter. So I hope to see you all look into it and possibly join. And with that, Janine, is there anything that you want to say?
No, just thank you for the opportunity. And I do want to give credit to my 17-year-old who made the slideshow for me.
There you go. All right. We'll put her name in the credits at the end.
There you go.
Official. Well, thank you so much for being a part of this and really important month of awareness and this important training topic. And thank you very much for all the work that you have done, for victims' rights and throughout the time that you've been in and out of family court, dependency court, and criminal court. We really appreciate you taking the extra time to speak with us today and drop some knowledge on us.
Thank you. Have a great day, everybody.
All right, everyone. Have a good one. Great weekend.